Wow, okay, so we are live. Hello, everybody. Happy Friday, happy 2017. It's 11:59, not 12 p.m. The reason it's 11:59 is because I'm too excited to go live today with Neil Garfinkel. And with such a great pleasure and honor that to have Neil as our very first expert speaker today. And Neil has been the voice and the face for our REBNY, the legal counsel to all residential broker in the city. And Neil has been really advising us broker to conduct our business according to the law and regulation, professionally, ethically, and really help us, everybody to become better. And also, besides that, Neil also helps so many buyers, seller, owner, landlords, everybody related to real estate, so much through the brokers or through his firm. He's the managing partner of AGMB. So, great pleasure. I'm really excited. Yeah! So here's Neil, and then Neil would everybody, in front of camera, a lot of people know about Neil, but we still need Neil to introduce himself.
Sure. Thank you. So Ann, thank you for having me here. Happy 2017 to everyone. The name of the firm is Abrams, Garfinkel, Margolis, Bergson. We are 22 years old now, so that's exciting. And I have spent my whole career representing lenders, buyers, sellers, all real estate related, a lot of residential, but we also do commercial, mortgage compliance. But what I'm known for is being broker counsel to REBNY, and in particular, representing real estate brokers. I've done it my whole career, and it's a great honor to work with you and to work with the REBNY community.
It is. It's truly throughout the whole so many years that we have so many questions, not just from us being brokers regarding to the law and the new regulations, and also from the owners and landlords, buyer and seller, all different kinds. We just have to continue to keep us updated according to the new regulation. And Neil has the core voice to us. And so previously in our Facebook Live broadcast, we had Jeremy Wang, the attorney. He was here to talk about the real estate transaction when you purchase and sell. And today we want to be more specific, talk about ownership in New York City real estate. And there are so many, it's such a broad subject, but it's really, really important. We have a list of poll questions that people ask. Just before it came, the reporter asked one very basic question. I'm going to jump right there.
Sure.
So, what is the land lease in New York City? We know that in the Battery Park City, it's known for its land lease, and we see the co-op and condo with land lease. So, what's the pros and cons?
So, first of all, land lease is a situation. It's kind of like what it sounds. Many co-ops own the property under the building. So they own their building. In a land lease situation, the co-op is actually leasing the building from another owner. And so the pros, generally, the value of the property or the purchase price will be less, and that's also related to the con. And the con is that depending on the length of the lease, the amount of the leasing payments can change. So there's not that certainty that you have if you own the property now. So if I'm representing a purchaser, for example, of a co-op in a land lease building, I've got to look at that lease and I've got to make sure and see what are the terms upon which their payments could change and all of those things. So with respect to Battery Park City, that is a little bit different. It's also a land lease. It is municipality based, so there maybe is a little bit more certainty, but we also, again, we need to make sure that we talk to our owners about what the ramifications are of that land lease.
So it sounds like if the land lease, the land owners are from the city, you probably have more certainty and security. But if it's from the individual owner owns a lot,
Right. So where there are land lease buildings that have individual or entity ownership, that is not related to to that municipal type of thing. So yes, and in those cases, again, we need to look at that lease. We need to see what the ramifications are, what the changes in the lease are, how long the lease is, when is it expiring. There are some buildings that lease is expiring shortly, and the owners there the owners in the co-op have some real challenges that they're going to be facing once that lease expires.
Okay. The second question is that when you are about to become the owners of the condo or shareholder of co-op, in the board package, there's a section, the power of attorney, that requests you as a purchaser to sign to give the power of attorney to the building, the management and the board members, and the usually the purchase asks that what does it mean? Why am I giving out the rights to?
So that would be in a condo situation, and what the condo owner is doing is giving the board of managers a limited power of attorney. So it's not a broad power of attorney. It is limited to doing certain things on behalf of the board of managers. And so it's not uncommon. Again, if I'm representing a condo owner purchasing, we're going to read that power of attorney to make sure that it says what it's supposed to say, that it's limited, but it could give the board the right to participate, or if they need to foreclose on a unit, for example, for failure to pay common charges. So the community as a whole, all the owners are giving the board of managers the right to act on their behalf. So it's not unusual to do that. You would not have that situation in a co-op, by the way. You'd have it only
in a condo?
That's correct. And it's a document that sometimes does get filed as well. So it will be, so that's not unusual as well.
And is there a certain percentage in terms of how many units in the condo related to how many board members?
It will vary from building to building.
Right.
So I don't think that there's any one particular number that I would say there. But again, these buildings are managed by a board of managers, and so that's very typical.
So in relation to that, another question by a co-op shareholder actually asked that the board member, do they have the right to just decide to add new sales requirement, or decide to increase the common charge or monthly maintenance on their own without the entire building board?
Sure. So both a board of managers in a condo situation or the co-op board in the co-op situation, they all have an obligation to act in the best interest of the other owners. And so there is limitations on what they can do. They can't act in their own best interest, and depending on what the situation is, they may have to have the ownership as a whole approve it, or there may be certain things that they have the right to pass as a board, but always with this idea that they have to act in the best interest of the other owners.
The other owners. So backward a little bit, you mentioned about the certain unit fail to pay the monthly. So another member also asked that what kind of impact when there's one owner or shareholder, they fail to pay the monthly dues, whether it's a real estate tax or the common charge and monthly maintenance. What kind of power does the condo or co-op board has? And what can they do?
Sure. So in the condo situation, they can sue to foreclose based on their lien if it's not paid. And in the co-op situation, the board can start a foreclosure proceeding to take back the lease, the proprietary lease, to revoke the proprietary lease. So both a co-op board and a condo board of managers both have certain legal rights if they're either shareholder or unit owners are not paying, and that obviously affects the rest of the ownership. Everyone is expected to pay their maintenance or their common charges, and failure to do so puts a stress on the other owners. So we do recommend that our boards and our co-op boards, they be vigilant, and they they make sure that they're staying on top of that.
Is the usual general rules that how many months must be gone by before the management and the board can take actions?
There is no particular rule. I suppose that each individual could set up and have a grace period, but I'm not aware of that. It's important to the community as a whole that everyone pays when they're supposed to pay.
Okay, so we know in this New York City, co-op and condo, there's also townhouses as well. I'll just jump in one quick question.
Sure.
There's a called PCD, a Property Condition Disclosure Act, Property Condition Disclosure Act, and the question is that what it is, and then are the co-op and condo owners, shareholder, when they sell, are they exempt from it, or?
So the Property Condition Disclosure Act requires that a form, the Property Condition Disclosure Statement, sometimes called the PCD, it requires the seller to complete information. It's a number of questions, and to give those questions to the buyer. It's questions about the condition of the property. It is not required in co-ops and condos. It is required in 1 to 4 family properties. And however, the law, I don't want to say it's an exception because that's not what the law says. What the law says is that if the seller does not complete the form, then the seller has to give the buyer a $500 credit at closing. And so we find that a lot of sellers, it depends on the geographic area. You may go upstate and the seller is always completing the property condition disclosure statement.
Yeah.
We find that downstate, a lot of sellers don't do it. They'll simply give the $500 credit at closing. So if you have a townhouse, though, the law says you're supposed to give that. The seller's supposed to give that. Not the broker, by the way. The seller is the one that would complete it. If they don't do that, they have to give the $500 credit at closing to the buyer.
So, since the co-op and condo are not subject to this Property Condition Disclosure Act, but as seller of the co-op and condo, if I recently have the leak in the apartment, then been patch up, are we as the seller broker obligated to inform the buyer?
So there's a number of different disclosure obligations depending on who you are. In New York State, with respect to the seller, is generally a buyer beware state. So it's up to the buyer to do their due diligence when purchasing a property. It could be a co-op, condo, house. If it's a house, we recommend that purchaser hire an engineer and do an inspection, because once they buy, that's their obligation. Right. Sellers can't lie, so they can't, if they're asked a question, was there a leak, and they know that there was a leak, they can't say no. There wasn't a leak. They can't lie. They also can't conceal something. So they can't, for example, if they know there's a leak in the ceiling, they can't patch over the leak and leave the leak in place knowing that that's going to be there. So that's a material concealment of those things. But absent that, the seller is not obligated to disclose everything that's wrong with a property. With respect to a broker, brokers have different obligations. So if you're the broker representing the seller, you actually have an obligation to disclose to a buyer any fact known to you which would materially affect the value or desirability of the property. So it's kind of interesting. There's almost a tension in the law that a seller doesn't have to disclose, but the broker, if they know about it, they may have to disclose. Even though they're representing the seller, they still may have to disclose to the buyer. So it's an interesting, there's interesting disclosure obligations that you as a broker have to a buyer. So
we often find that the buyer they're interested in knowing why the seller is selling. They consider it as a part of their element for negotiation power. And oftentimes the seller broker is really not required to tell the buyer why the seller is selling, right?
In fact, I would tell you, and again, your obligations as a broker vary depending on who you're representing. If you're representing a seller and a buyer is requesting why the seller is selling, you have your fiduciary obligation to the seller, and if they've told you not to disclose those things or it would be detrimental to your seller, then you would not disclose that. If you have something called dual agency, where you're representing the buyer and the seller,
Right.
which is common in New York, then depending on the particular situation, you might or might not disclose that. Even a dual agent has an obligation to maintain confidentialities of each party, and the motivations for selling may be something that you should not disclose. So those ideas of disclosure will vary from situation to situation.
What about one thing very particular, any kind of criminal activity that happened or once happened in the property that, for example, stabilized property?
Yep.
Murder or death or what?
Yeah, so it is called we call it the stigmatized property law, and the theory is that certain things, for example, a death in a property or a crime, shouldn't stigmatize that property. So it's actually written into the law that says that a seller's broker is prevented from disclosing something along those lines, a death or an illness, a non-contagious disease, or a felony, for example, from the buyer. They can't disclose that unless the seller gives them permission to do that. So it's a little bit quirky in the law, and again, it goes back to the importance of the broker understanding what disclosure obligations
Right.
they have, as well as the owner.
So we talk about all these detailed questions. Seems swing between the seller and the buyer. Once you become the owner, you want to sell. That related to one really huge subject, the fair housing laws.
Yeah.
The fair housing law is such a big topic that. As a broker, and whether we represent a seller, buyer, or landlord, oftentimes we will ask questions that we cannot answer. And the reason we cannot answer is due to the fair housing laws. And for example, before we introduce fair housing law, because when we realize that as a broker, we are educated by Neil Garfinkel, but as a lot of owners, a lot of buyers, a lot of landlords, when they want to sell, want to rent, they have no idea about this law.
Sure.
Have no idea that they can be in trouble if they limit certain, request. And for instance, if we in the lobby, buyer asks, are there children in the building?
Right.
I'm sorry, I cannot answer. Then they'll often say that I don't want brokers in my building. I don't want this and that and that and that. And those questions, those requests are really illegal against the fair housing law. So Neil has been giving us so much education, and we really have an opportunity to give out to the public. So here's perfect opportunity. Everybody, eyes open, ears open.
So obviously fair housing, I've been teaching fair housing. I created the fair housing course for REBNY 10 years ago. We've seen more changes in fair housing laws over the last year than I saw in those first 10 years. And so it tells us that fair housing is really important, which it is. The way that our fair housing laws work is that there are the law creates what's called protected categories, and those protected categories, for example, age or sex, occupation, those are all protected categories, which means that someone cannot be discriminated against based on being part of that protected category. And so you bring up a good point, and which is occupation, for example. Occupation is a protected category in New York City. It's not a protected category in potentially other places in New York. So as a broker, it's very important to know what the protected categories are where you are practicing. Similarly, if you're an owner, you need to know what those protected categories are. The fair housing laws apply to everyone. And so they apply to owners. Now, there are certain exceptions to fair housing laws. And an owner, for example, in a two-family house may have the right to not follow fair housing laws. But I would caution that owner to speak to an attorney before they decide that they're not going to do that.
So can I jump in
Sure.
just to describe all the protected class in the fair housing law, the federal fair housing laws, and New York State human rights law, New York City human rights law. The following classes are protected.
Correct.
Race, family status, color, nation, religion, disability, what is physical, mental, your gender, your citizenship status, your partnership status, that's applied to New York City, gender identity, and your lawful source of income.
Right.
Those categories are protected in the fair housing law. So the owners, seller and buyer, board member, everybody in New York City, please aware of this. Yeah. Sorry.
So no, and I think that's a good point, right? There are a number of protected categories. And again, it's the idea is to protect people. The overall concept is that everyone should have the right to live wherever they want to live, regardless of their characteristics. And we always say to the broker, look, you should never be describing the type of person you want to live at the property. You just want to describe the physical characteristics of the property. So it really shouldn't matter. But again, the law does set up these particular protected categories. And we want to make sure that the owners and the brokers know what they are. An owner, for example, can never, even if they don't, again, going back to the owner that has a two-family house, for example, and may want to rent the upstairs unit, they can never advertise or make public their decision not to, for example, rent to a family with children. So they can't advertise it, they can't make it public. If they do, they are violating fair housing laws. So they're complex, they are, and again, if you're an owner, I recommend you speak to an attorney. If you're a broker, we train lots and we've done training, so it's important that you understand what the fair housing laws are and where the property is located, where you're conducting business, because they vary from place to place.
So is there exception to the fair housing law protected class? Like what type of people are actually not protected? Yeah,
so first of all, no one can ever discriminate based on race or color. You can never do that.
Right.
So the exceptions don't apply there. The exceptions can apply. A broker can never work with an owner who may have the right not to follow fair housing laws. So again, complex, well beyond our presentation today, but it's important that everyone be aware that those fair housing laws are there, they're being enforced, and they're important. They're important to protect people.
But one thing is the criminals are not protected, right?
Great question. So recently, 3-4 months ago, HUD, Federal Housing and Urban Development, Undersecretary for HUD, came out and said that owners cannot have a blanket policy that says, I will not rent to someone with a criminal conviction. So actually, having a criminal record is not a protected class. However, based on a concept called disparate impact, which was an issue that was discussed in a Supreme Court case, the law says that you as an owner cannot have this blanket policy that says, I will not rent to someone who has a criminal conviction. And it's a little bit more complex than that, but the theory is that because people with criminal convictions statistically belong to certain racial and ethnic groups, that if you have that policy, by virtue of that policy, you're effectively discriminating against certain racial and ethnic groups. So if you're an owner, you can, and you have that policy, you should change that policy, and it should not be the blanket policy. You can ask if they have a criminal conviction, and then in certain cases, if you have a legitimate business reason for not renting to someone because they have the criminal conviction, that is still legal. But the overall policy of saying no one in this class, then you can't do that.
I see. Okay. So the fair housing law, and the other question is that when you buy in New York City, the co-op, and we have high percentage of the properties are actually co-op, and the co-op actually they have a right to reject the purchaser without giving the reason. And previously, one person asked that can they reject the purchase based on the fact that the buyer is not a citizen, and we seem to cover fair housing law. So clearly the answer is that cannot.
No, they cannot, right? So a couple of points there. First of all, citizenship is a protected category, There is no restriction on someone buying in the U.S. They don't have to be here. They don't have to be a citizen. So there are no restrictions on that. With respect to co-ops, co-ops have an obligation to follow all fair housing laws. Always have the right, depending on where the co-op's located. In New York City, they do not have to give a reason why they're rejecting someone, but they can't reject someone if they belong to one of those protected categories. So the idea of rejecting someone because they're not a citizen would be illegal. It would be against our fair housing laws.
So if somebody, they are perfectly financially qualified, whether you want to purchase in the co-op, or you want to lease rented apartment in a co-op, but you were rejected, can the seller and the prospective purchaser find out a reason and remedy the circumstance?
It depends where the co-op is. There are certain places in New York that actually require a co-op to give a reason why they rejected. But again, in New York City, we don't have that obligation, so it is very difficult to find out. I would like to assume that the co-ops follow fair housing laws, and I always teach that. You have to assume that the co-ops follow fair housing laws. There's really no way to know in many circumstances, so we assume that they're going to follow the law, just like we expect most people to follow the law.
So I have one, the client, he's really very savvy, educated, highly educated banker. And he asked me that, is there a benefit to me for me to serve as the condo board member in my condo?
And I think, look, I would encourage, we started the conversation talking about failure to pay. And if you live in a community, I think it's important that you're involved in that community. And I think it's important that you participate. And there are rules that the co-ops and the co-ops institute. So I would highly recommend someone, if they want to see how, if they're concerned about how their building operates, then yes, they should participate. And accept it. Sometimes I say that a broker should not participate on a board and do deals in their building, and we can talk about that at another time. But if they're not a real estate broker, then sure, I would encourage someone to get on their board.
I see. That way, if your board function well, can also increase the building value, right?
It does. I think that a strong board, a strong building, a well-functioning building absolutely adds to the value of that particular property.
And so, so many owners ask about this diplomat. The diplomat immunity, how does it work? And then when they want to rent it out, can they say no to diplomat? Are they protected?
Right.
We just mentioned.
Yeah. So diplomats are not a protected class.
They are not.
Citizenship, national origin is a protected class. The reason why diplomats are not protected is that they have something called diplomatic immunity, which is a status. So if you're, and what diplomatic immunity says is that in certain cases that the diplomat can't be sued. So if there is no recourse, for example, if a landlord has no recourse against a tenant that is refusing to pay, that can be very problematic. And so it's the status that is being addressed there, the status of having that immunity. It's not the fact that they're from another country. It's not based on their citizenship or national origin. And so yes, there are buildings or there are particular instances where someone can say, look, I'm not going to rent to you. I don't care where you're from, but because you have that immunity. Now, what's interesting is that not everyone has diplomatic immunity. And we sometimes hear someone say, well, we'll waive the diplomatic immunity.
Oh, yes.
And it's actually the sovereign body that has the immunity needs to be the party that waives it. So again, it's important that if you're an owner, you're a broker, and you're faced with a situation that involves diplomatic immunity, I strongly recommend speak to an attorney. Make sure that you have some good guidance there on how to handle the situation so that you're not violating fair housing laws, that you're protecting yourself, and that you are doing the right thing.
Do you know that it's really not easy to a very, very knowledgeable broker without Neil's help?
Well, and we, brokers are expected to know a tremendous amount.
Yeah.
I think that there are times where brokers are not given a lot of the credit that they're due because they are expected to know so many things, and they are such an important part of the transaction that that again, I think that there is this misconception that, oh, you know, you're just a broker. Well, people, and I spend my whole career training brokers, so trust me, I know the importance of being well educated, well trained, and being a real professional.
So our session is 30 minutes, and already give me the hand. That means the time is almost up, and Neil has been so generous to give this 30 minutes out of his such busy schedule, because it really demanded by his old parties from everywhere. But one of my clients asked me, please ask this question on his behalf. So he wants to purchase in a co-op, and very soon will be co-op shareholder. He's a young professional. He said that, hey, can I sublet or can I rent out part of my apartment to have income, help me to pay the monthly cost?
So, well, and so New York, I think what we're talking about is a couple of different things. So there's the roommate law. The roommate law says that you have the right to have someone live with you, and a landlord can't say no to having that person live with you. So there's a distinction, though, between someone living with you, cohabitating, as opposed to renting your apartment. That's when it implicates, there is also, like, for example, the Airbnb, for example, but there are laws that say, in New York, that say that if you're not living in your apartment, you can't rent it out for periods shorter than 30 days. If you are living in your apartment, you can rent it out for short periods of time. So there are a number of different things that are going on there. In addition, the co-op may have certain rules against renting out versus having someone live there. If you live in a co-op and you want to have someone live with you, the roommate law does apply. As opposed to if you're trying to rent it out, that could be problematic. So the kind of, I'd need to look at that situation and evaluate that a little bit more.
So it was just as simple as that I own in a co-op and or I own in a condo, that I want to rent out my living room to somebody else, and then I do not need to have the co-op board approval. I have the right to.
It again, could be problematic depending on the co-op or the condo, right?
So we talk about the roommate law. There was actually the New York City occupancy. Look, I don't know whether Neil has a quick minute to cover it.
So New York does have occupancy standards. That's different than fair housing laws. It does. New York City basically says that you can have one person per 80 square feet of living room, and so, which is actually a lot of people. So the occupancy standards, the roommate law, fair housing, they are all potentially implicated when we talk about limiting the number of people. And again, I would encourage you as a broker and owner to speak to an attorney when making these decisions. And also the co-op has certain rights. And so again, all of these things play together, and I think you just need to be aware that they can be implicated, and you don't obviously want to be violating the law. Great.
If I open my mouth again, I'm going to have Neil sit here for another 10-20 minutes. But Neil is really busy today, so we have to really stick to our 30 minutes. And I think we're already 35 minutes. So we have so many other questions that we haven't even got there yet. So clearly that we would need to have another opportunity sneak
Anytime.
into
Happy to do
Neil's
it. Sure.
schedule.
Absolutely.
Thank you. So it's a Friday, first Friday of the whole year. Go celebrate, enjoy, and then come back next week for a really amazing second week. Thank you. Thank you, Neil.
Thanks. Thank you, Ann.